All right, we are here. Parties are here a little bit early, so we can go ahead and get started a little early. This is case 232246 SC, Coulter Purdom versus Graham Carter Homes LLC. This is a small claims case. In other words, parties are asking to have this resolved here in front of me in small claims. What that means is parties cannot use an attorney, and they're also foregoing their right to ask for a jury trial. So first things first, if both parties are ready to proceed here in this fashion, then the way that we would start is by swearing everybody in. I cannot see you, both of you have your cameras off, but I would ask that you would raise your right hand so I could swear you in. You swear or affirm that any testimony you give here today would be the truth, the whole truth, and nothing but the truth. Other right hand.
Yes.
Yes.
All right. So this seems to be pretty straightforward. I don't get too much information on these, but at some point in time, Ms. Purdom, you were a tenant. That landlord-tenant relationship is no longer in place, correct?
Correct.
You don't live there anymore.
I do not.
Did you guys have a case in landlord-tenant court at all?
No.
All right. How much was the security deposit?
The security deposit was $1,500.
And when did you move out?
I moved out September 1st of this year.
Okay. And did you have a forwarding address?
I did not.
Okay.
But I did ask, it was July 26th. I just asked what they needed from me, and I never received a response or anything from them pertaining to leaving the premises.
All right. So where is it they were going to send your security deposit?
To the duplex that I was living at.
After this?
Yeah.
Okay, that's what I mean by.
Well, most of our communication was done via email.
Okay, here's what I mean though.
Yeah.
When you leave the address that they were your landlord and go to the next place that you live, did you provide them with that address?
I talked to Tony, the other partner in this. That I was telling him that I was moving to Lake Allegan to Indian Shores.
Okay.
But that was a verbal
communication. Did you ever get any information of that they were claiming damages?
I did not.
All right. And so Graham Carter Homes LLC, who are we speaking to?
I'm Tony.
Okay. Tony, what do you do for the LLC?
I'm a partner.
All right. I just need to make sure you're able to speak on behalf of the LLC. So you have a tenant that moves out. They had a $1,500 security deposit. What happens next?
Well, in this particular case, I was made aware that she was going to leave. And when she did leave on the 1st of September was the first chance I had to see the condition of the unit. There was somebody that wanted to move in that weekend right when she moved out. And so when I first got a chance to see that, it was very bad condition. Everything needed to be addressed in the house.
And how long did she live there?
She was supposed to be there for 2 years. She moved out a little early. She had a 2-year lease. She moved out a month or two early, which, you know, personally, I didn't care, but she did give us notice she was going to go.
All right. And did you send her an itemized list of what was considered to be damages from the apartment of why you were withholding the $1,500?
I did.
Okay. Nobody sent that to me.
I apologize.
Okay, that is the meat and potatoes of whether or not I would order the $1,500 or not. As a landlord, if you want to keep that security deposit, that's fine. You have to produce in writing for the tenant why you are doing that. And you're saying you did that. So
I did. I have it in front of me.
Ms. Purdom, you got that?
I got almost 2 months after moving out. I did follow through with my 2-year lease. I just moved out 4 days earlier. I signed 2 years prior, on September 4th, and I moved out September 1st. So I was only
All
3,
right.
4 days shy.
And so, Tony, what's your last name?
Boma, Bouma.
When did you send her this list?
It was probably sometime after she requested her deposit. I'm being shown October 26. The first I heard
Okay.
from her was about a little over a month after she moved out, asking for her deposit. I was very shocked. It appeared that she left thinking it would probably cost her that much or more to put the house back in order. So when I found out that she was expecting her deposit, that's when I sent her a breakdown of what we did to her place.
Okay.
Put it back in
So
order.
let's school you in the rules of being a landlord. Miss Purdom, how many apartments do you own and you rent out to people?
I don't rent out any units.
And Mr. Boma, how
Uh,
many doors does Graham Carter Homes LLC have?
These are actually brand new. We built them about 2 years ago. Coulter was actually our very first tenant.
All right, that's not an answer to my
7.
question, sir.
Oh, how many units? We have 14 right now.
14. All right. So here's the rule. When a tenant moves out, you have 30 days to do one of two things: return their security deposit or give them in writing why you are not returning the security deposit. After that 30 days, not only do you owe them $1,500, you owe them double the security deposit. You are the one with the obligation. You are the landlord. You have the power in the relationship. Is this the first time you're hearing that?
This is the first time I've had to deal with this situation. That's correct. We've had probably 3 or 4 tenants that had to move out because they moved on, their lease was up, and they left the place like they got it. These were brand new. So Coulter moved into something that was brand new. And
All right.
I
So
just
here's the
didn't know
good
she was
news. I'm not
expecting.
going to penalize you double the security deposit because that's not what Ms. Purdom was asking for. And I think there's probably some gray area here of legitimate damages you could have claimed. But you missed your window to do that correctly. And therefore, what's going to happen here is you are going to be ordered $1,500, the sum of the security deposit, to be returned to plaintiff. Plaintiff also paid certain monies out of pocket to get us here today. She had to pay a filing fee to court. She had to pay to have you served. That's $62. She's able to recover that as what's called costs as opposed separate from damages. So, sir, especially if you own 14 units, I would advise you to look over the rules for landlord-tenant, which governs how that relationship works, because there's plenty of things that if they don't come up, they're not a problem. But if they come up, by the time you get to court, they are solid lines. And if you simply don't do them or miss those deadlines, you will lose in court all the time. All right. Now, because we had a contested hearing, both parties, either party has a right to say, I don't agree with what just happened there. If you wish to contest this further in front of the district court judges, you must do that within 7 days of today's date. Otherwise, that window of opportunity closes, and you must come into the court and do that in writing. Do you understand your rights on appeal?
I do.
All right. Then other than that, I will type up this order and send it out to parties. I will remind parties, the court does not do collections. We are expecting that the parties would be in touch with each other to do this, what's called the satisfaction of the judgment. In other words, for the money to change hands. But other than that, we are all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.